Good morning, everybody, and welcome to this edition of Roll Call. I'm your host, Joseph Giacalone, and with us we have a very special guest today, criminal defense attorney, extraordinaire legal pundit, Joshua Schiffer. Josh, thanks for taking out the time and doing this for us today.
Hey, good morning, Sarge. Thanks so much for having me. And man, this is a great week to talk about true crime.
Oh my God.
We got a unique fish on the line. We were just talking about it before the show started, there's never been a case, at least in my memory, that has dynamics that are quite like this.
And the vitriol from both sides too is actually amazing. I've never seen this. I mean, I think we'll see some of this in the Koberger case coming up forward, but I don't think it's going to be anything near this.
I don't think we get the community reaction and engagement because, someone pointed this out online. When's the last time you ever saw a crowd of people show up to support someone accused of killing a police officer, especially one that wasn't, super highly politically motivated? This isn't, some hot topic political case. No, this is local town, county, city, state business. And you've got this vitriol from both sides. It's unlike anything I've ever seen. And I really wonder exactly how much it's going to affect or whether it is affecting a jury, because this is a tiny court. There's no way the juries can avoid just this seeping into their province.
Well, and not only that, I mean, that was specifically done by the defense, right? They wanted this small court. They wanted to make sure, I guess, that they weren't able to stuff the courtroom full of cops, right?
Yeah.
They stripped them of the uniforms too. The judge wouldn't let them wear uniforms. All that crazy stuff. I mean, it just one thing after another.
There's definitely been some, you talk about how strategy works and strategy, and there are people that spend a million hours on the most teeny tiny details, and there are then people that just go on in and let it fly. This defense does seem to be focused on those details, like the courtroom selection. I agree with you that the tiny courtroom, that's very specifically done by the defense, and it's an attempt to ice up these witnesses, to jam everybody together, to make it uncomfortable. And Sarge, you've been at trial. It is kind of like a little war. You show up and it's wearing. It's 24 hours a day, and the conditions that you're in, that really matters when it comes to a long format case like this, because you are packed in there and it is uncomfortable and people get frustrated and tired. You got to use that to your advantage. Timing matters. And if you're wearing people down and you can remain sharp while they get dull, that's a win.
Right. And I used that as an argument because a lot of people say that the judge was being biased in regards to the prosecutor and stuff like that. I'm like, this was a big decision that she made that was two things that really helped the defense: the small courtroom and not allowing cops to wear uniforms, because that officer Sarge showing up in that suit and tie makes him look like a detective, and also makes it look like it's part of this bad police work that we've seen so far. And I think that was a really important win for the defense too.
Yeah, I think it's an important win for the defense. I understand the lack of uniforms more because it does need to be limited to security. We've seen a couple cases where packing the courtroom can actually go and hurt the other side. So I like the idea that the judge is trying to remain a little bit uniform, and also preventing the general public, because allegations, and I don't know, I'm not there on the ground, is that literally some of this PR on the outside is exactly that, PR, that there are paid, organized people bringing forward narratives that are much more aggressive than you would normally see in a local defense, even a reasonably high profile one. But in this new era of digital media and local citizen journalism, we may see this kind of more and more. Like, bluntly, this isn't the first time I'd run into one of the people involved in this case. The Turtle Boy guy got sideways with a friend of mine from college in Worcester, a local newswoman, probably 5-7 years ago, and that's when I first, was introduced to him, and it was a little bit shocking. He was saying and doing some extraordinarily inappropriate things. And I kind of wrote it off as, okay, this is just some local Yahoo crackpot. But now look at the influence he wields. You could legitimately say that the journalistic work that he's doing has moved the needle on the case. And now he has spawned, I don't know if you want to call it competition or what, but it looks like this super micro journalism universe is expanding and expanding.
Right, and then now we're going to see in the next trial, see who wants to one up him. That's my only other fear, that we see that this becomes more of an issue in getting into the weeds, so to speak.
It's like you have years of experience with human nature, Sarge. Like it's like that some idiot crack yank hole is gonna have to one up him and be, oh, you think you can do it like that? Wait till I do it like that.
Yeah.
And what's interesting about courts is that this is Judge Beverly's court. Like, she's gonna run her way. Very different from the way that other judges may run courts. We see that in all of the different trials that we watch. Most states vest enormous discretion into the court trial judges to run the courts the way they want. As long as it fits within these big parameters, the judges really get to run their show. And I have judges where you don't step out of line just by the littlest iota without getting clapped back. And I've got judges where it's, kind of like the lazy teacher in high school where you show up, you don't. All depends. That behavior could get a very different response in a different jurisdiction.
Know your customers, because that's going to be it. So they poke mom at ass. He says, we need a name for the kitty cat. What's the cat's name?
Oh, this is Justice Kitty. Justice Kitty is a rescue. I love rescuing my animals, and she and her other sister, who is also Justice Kitty, are on Twitter with me pretty regularly. My daughter is a cat person, which was a great disappointment to me as a lifetime kind of dog guy. And at a certain age, as a young girl, I needed to incentivize her to stop camping on the floor and to sleep in her bedroom. And after certain offers and acceptances were made, I'm now a cat guy.
There you go. Converted. So I have to ask you, why did they charge murder in the first place in this case?
And that's really a fantastic question, because it's at the heart of it. So let's talk for just a second about how charging decisions are made and how cases happen, because it'll explain why we got to this part. A crime's going to occur. Let's just say a criminal action happens on January 1st. In most states, when that crime happens, no one's aware of it beforehand. There's not a pre-existing investigation. These people are not already on law enforcement's radar. Now, this is for a state prosecution. So if a death occurs, law enforcement's going to come out and do an investigation. Now, if it's a regular civilian death, that's what detectives and law enforcement go out. They investigate. The patrol officers, the dispatch officers are going to come out. They're going to secure the scene. Then detectives are going to show up. Crime scene techs are going to show up. They're going to secure the scene. They're going to do an investigation. During that investigation, the detectives are going to make some decisions involving what might have happened. Oops, sorry. Justice Kitty wants to knock stuff around. So the officers will make these decisions about, oh, this is what happened. And they may choose to effectuate an arrest after getting a warrant. And depending on what the evidence shows up, that warrant is going to be for murder, manslaughter, all the different charging choices that are available in your jurisdiction. And most jurisdictions in the United States use a variety of the model code, which has been adopted by most states. So we've got the officers making a charging decision on the scene and probably arresting someone, but that's just to put someone under arrest. That's not an indictment. After that charging decision, the investigation is going to continue, and when the investigation is done or mostly done, the prosecuting attorney is going to present the case inside their office to probably a team who's going to make final charging decisions. And that's a really hard analytical choice when you're dealing with capital cases because there are a lot of limitations. There's also a lot of advantages the state can get at this time because if you charge stack, which is multiple charges for the same activity, one on top of another, you can figure out some really strategic leverage by adding and subtracting certain associated charges. It's why one death could actually result in 5, 7, 10 different associated charges. But that prosecuting attorney, most often going to be elected, makes a charging decision. Then they will present those charges to a grand jury. And a grand jury, if they want the grand jury to return a true indictment, most of the time that's going to happen. Grand juries are a unilateral, one-sided rubber stamp process where only one side shows up and they say, we really think that these crimes occurred and here's our evidence. And if you think that we should prosecute this person, please say yes. And that's really where the charges happen. Now, even after that, as the case continues to develop, you can have superseding indictments where the existing indictment or charging document can get dismissed by the prosecution. Say new facts have been developed by the state or the defense, and it justifies that. They'll dismiss the existing charging document and replace it with a superseding indictment. And that's got a bunch of time issues attached to it. But that charge of how to go, if it's going to be murder in the first, if it's going to be manslaughter, that's going to be made after the investigation by the charging agency.
Right. So in this case, we're dealing with, and I think a lot of people are beginning to understand it, but the defense doesn't actually have to prove anything. Everything has to be done by the prosecutor. And as far as I'm concerned, the prosecutor has not done a good job. We'll be nice on that. He hasn't done a good job.
I feel so. My mentor, who taught me a lot about criminal defense, is you always need to identify the victim as well as the villain when you're telling a story. And in a criminal case, for one of the first times, I almost feel like the poor DA is a victim because this DA has been handed a terrible investigation. Awful. He has been handed witnesses that are disastrous. And I originally was kind of questioning, man, why is this guy starting off so soft? That's because he didn't have a lot of hard to go in with. He couldn't barge in there and be like, we've got this great. No. That opening, his mentality during this case has very much been, listen, we've got this dead police officer and we think we know what happens and we're going to have a case about it. But yeah, you're totally right. Under the United States Constitution, one of the gorgeous parts about it is the state carries the burden. It is 100% the state's burden. No one can change that. It is always going to be the state's burden. You'd have to do nothing in a criminal accusation except show up. You don't have to speak. You can't be compelled to speak. You can't be compelled to really do anything.
Right. And we've had a lot of, we're going to get into some of the characters. We'll just call them characters in this case as their witnesses. But for the first 2 weeks or so, 2.5 weeks, it seems as if even the prosecutor's witnesses have been positive for the defense, right? And in so many ways. And it's kind of like a head scratcher in certain aspects.
And that, so we talk a lot about burdens because the state has the burden to prove you guilty beyond a reasonable doubt. And in this case, the interesting, very aggressive and proactive defense that David Yannetti and Alan Jackson have put forward has kind of swapped that. The state didn't have the firmest factual defense. So what did the defense do? The defense turned around and created a defense that is basically framing and put that burden back onto the state with its aggressive cross-examination. And while you don't have an obligation as a defendant to do anything but show up, you do have the option to create an affirmative defense. And it's not a formal affirmative defense. The formal affirmative defenses are alibi, and it's things where you actually are self-defense, where you actually have to provide your own evidence. In this, it's all being done through cross-examination, but they've injected into the jury very effectively the idea that this is a cover-up. And we've now gone from the state just cleanly carrying a burden, she did this, to, whoa, does the state have to disprove a cover-up? That's an additional burden. That's an additional barrier. It's not the way that an effective case is prosecuted. And it's been kudos for the defense to do that. It's not easy to do.
Yeah, and the defense has put that, I think, reasonable doubt in a lot of people's mind, even watching it, about this crime happened inside the house. That I tell you, if I hear the interior description one more time, I could probably draw this house without ever been there. I mean, I've had enough of that too.
And we talk a lot about, the global arc of how people defend criminal defense cases. And 20 years ago, when I got in, law enforcement, when they said something, it was generally held as, man, that's going to be the truth. No one considered really second guessing, especially senior agents, detectives, things like that. Over the last 20 years, we've really seen the cynicism in jurors rise. And that allows for defenses like this to become more effective, because you're just asking the jury, hey, ask a few more questions. And you're pointing out to a jury, hey, this is what an investigation should look like. Y'all know that because you watch the news. Now let's look at the investigation we had in this case. Is that enough of an investigation? Because juries are asked to do something very hard. They're asked to agree with 11 other people. I don't know when the last time you tried to get 12 people to agree on something.
I can't get my wife to agree on dinner.
Yeah, it's hard under the best of circumstances. Then overlay that, some sort of horrible trauma and crime, a whole bunch of rules, take everybody out of their comfort zone and put them in an uncomfortable room. It's quite a burden for the state. And admittedly, the state's got a lot of rules that support it, and the system is meant to benefit the state as much as possible. But still, it's a big challenge what the state has to do. By changing the dynamics in this case, by shifting that burden around, and by creating something the defense doesn't have to prove, it just gets to allude to, that increases the likelihood a jury's unable to get 12 people together and agree. I always am talking about the two fears of a jury. Your average jury has a fear of wrongful conviction and a fear of wrongful acquittal. Traditionally in America, an American universal truth is that it is better for a guilty man to go free, or 1,000 guilty men to go free, than for one innocent to suffer. And our system is designed with that in mind. It's why we have 12 people agreeing unanimously for a verdict. It's got to be strong. System's got to be strong. And this is where we really see the weaknesses in our system illustrated because of artful lawyering and this burden shifting. And I look forward to seeing it continue. Wait till Proctor gets on the stand.
Oh my God, that's going to be a popcorn event for sure. I mean, that one's just going to be, I'm going to be sitting watching everything. So, because one of the things I do is so I'm not a lawyer, as you know, I look at the thing with the cops specifically, and of course what the witness is saying. And I pulled apart the whole cop thing, the police thing already. I've been really disappointed. I went on a rant. I don't know if you saw it, about a 5-minute Twitter rant on after watching that lieutenant not know what evidence tape was and everything else that goes along with it. So, like what you're saying, the cops handed him a bag of crap, let's just call it that, and said, here, prosecute it. And it's just, like you said, and you're dealing in this still anti-cop environment, anti-government environment. I mean, and we're outside of Boston where the Revolutionary War basically started. So everybody's got it ingrained in that.
It fits into the narratives that I feel jurors are looking for. If telling a compelling story will attract people to you, and if you can create and tell a compelling story, people will exclude other stories, other versions, other beliefs in order to pay attention to your version. And what I'm seeing, and again, we only get to view this from our perspective outside, knowing all the other stuff. We don't have that limited viewpoint of a jury. But from what I'm seeing, there's really specific questions that would need to be asked from these officers, specifically Proctor, observation from a good investigation happen. Like, there's just going to have to be answering these tough questions. And the real art in cross-examining a Proctor is, do you go out there scorched earth and kick his ass? Because that's totally something a lot of people would want to see. They would want the just, fire, brimstone. I'm a defense lawyer. I'm going to go kick the crap out of an officer because I can, and I'm going to be a big old butt. Or do you get Proctor to actually talk about how he polices and what really happened with this case, which then makes the jury ask the questions you want them to? And that's the highest form of lawyering. If you can get a jury to ask the questions internally with their own internal dialogue that you want them to ask, that then bring them to the conclusions you want them to ruminate on, that's moving the needle, and that's advocacy at the highest level. Because if you're explaining, you're losing. That's the problem that I'm seeing in some of these states' witnesses, is it looks like they're trying to explain that John was murdered. They're trying to explain that it had to be Karen. They're not saying what happened. They're trying to persuade and put their perspective on it. And I think that's because somewhere behind the curtain, we're not knowing the rest of the story.
Right. And it's a great point that you bring out in regards to that. Now, Proctor is to me, he's the crown jewel for the defense. And at this case, if the defense is saying that she's been framed, they have to go after him because he's the one that's running the investigation. And now we're starting to see a little, chinks in the armor, right? We saw some testimony today that we're going to get yesterday that we're going to get into because we have some contradictory statements, and it's going to be bad news. I mean, they have to go after him.
Yeah, and it's really so. How do you go after him? There's a lot of so first of all, obviously he gets to do his direct examination, and you're going to see the prosecution. You're going to see Lally really get out there and try to probably bolster Proctor and nip off whatever he can about the known attacks. They've already pre-gamed this. They've already prepared Proctor with the problems with his expected testimony. If they didn't, they're ridiculous. So Proctor's gonna have some pretty solid responses to known questions. It's how he presents those. Are they going to come off canned and defensive, or is he going to come off as natural and instill some trust in the jury? Because Lally's going to really try to make jurors understand that this is an officer who showed up to a hectic, difficult scene. There was a lot going on, and you don't have to have a perfect investigation to know what happened. I think Lally has lost the lead with telling the straightforward story that this is a case about a drunk lady hitting her boyfriend and driving away. And they've tried to tell a straightforward story, but they can't. They keep getting brought off onto the side. Proctor is the big wart for the state, but he's also the one that could unify the state's story. And I really wonder how it's going to turn out.
Well, me too, because I don't have any faith in exactly what he's going to say, because the whole thing about the text messages about basically it's like bribery. I mean, it falls under bribery. I mean, if you're asking for a gift to give to somebody you want, it's that falls within the statutes.
Yeah, and it's that willful blindness and wink and nod, and it's how much BS are people really gonna buy? So I believe in humanizing witnesses because that's how you get authenticity. And I don't even have a problem if I'm a state prosecutor about humanizing police officers so that juries are given permission to let police officers be imperfect. And I think that the state misses that in so many cases because the public comes in with this presupposed belief that we're going to hold law enforcement to the absolute highest, nay, I say, unachievable level of professional training capabilities, etc. And any deviation from that, the defense attacks and they jump in and they try to rip it. No, I feel that an effective state attorney, an effective advocate working with law enforcement should be able to give the jury permission for humanity. and that officer is a human being. And while there's an aspirational goal of a perfect investigation where everything works, guess what? This is real life. And policing, hey, you could be in the academy for 20 years and not see everything you see in just 1 year walking a beat. There's no way you can be trained for every possibility. And I think that the state's going to have some opportunities to rebut some of the evidence preservation stuff, to rebut some of the investigatory stuff, because not to make light of a situation, in some ways, I turn around and go, all right, this case is a dispatch to a really sad drunk deceased on the side of the road in a blitz. Oh my God, he's an officer as well. Okay, send out the crew, get this one wrapped up quick, and everybody, let's go. Like, I can understand why, in a weird way, the investigation wasn't a super deep, thorough, and professionally done one. I just, for the state's fact, I wish they'd done a better job.
The storm plays a factor in this, and the fact that Massachusetts State Police didn't come out on the crime scene like they're supposed to, and
Yeah.
it kind of got left to the Canton Police, which raises my questions. What is the training that these people got in order to do the what if scenario? Right? Sometimes, police departments don't prepare for the what if scenario. They say, it's never going to happen.
Yeah.
But here we are.
And the cross-examination on the training is one of the places that defense attorneys mine for gold. I've done it. I think every officer, it's probably one of the parts that intimidates them the most, because it's the easiest opportunity to kind of gotcha a police officer. All officers have extensive training. Outside mandate or academy, officers have to attend dozens, if not hundreds of hours of training every 1, 2, 3, 4 years. This training, since it's codified, since it's standardized and regulated, and it applies across the entire police force, that gives defense attorneys a platform to basically rake them over the coals. And if you have ever felt nervous being on the spot, getting quizzed about something, that's kind of what these officers go through when it comes to cross-examination on training and policy. You've got some smarmy lawyer like me who knows way more and has his piece of paper in front of him and has worked on these surprise questions outside of court. And I'm going to try to present myself in a way that makes me seem really attractive to that jury over there, while making you look dumb, asking you questions that you can't possibly know the answer to, because I'm going to ask them in a way that, sorry, man, I ask questions for a living. You're going to sound crappy. And that's a really, it's got to be interesting to see how they go against Proctor. Are they going to really try to light them up, or are they going to soft pay?
Right. And it's even that I see some of the defense techniques where Yannetti and Jackson are asking those rapid fire questions, trying to get an answer out before they can be objected against. And they've actually won a couple of those because the person answered it and then they said objection, so it's something that I can't believe that people still fall for that.
It's not the objection game as much as it's managing the patter. And Lally could get a little bit more aggressive with defending witnesses. There are so many different concepts on how a cross-examination should take place, and it depends on a combination of all kinds of things, including the witness's personality and the facts. And if you don't have a lot of time in a criminal case to work with a witness before cross-examining them, because you don't have access to them, they don't have to talk to you in a criminal case. So this may be the first time you ever get a chance to really speak with this very important witness. The rapid fire is something you train on, because when you can get it down to a simple back and forth and you have a pre-programmed place to go and you're asking non-objectionable questions, it's a really efficient way to transmit a lot of information to a jury in a way that they encode it into their brain. Whereas if you fight about questions and answers, and you'll see witnesses and lawyers really labor over the form of the question, rephrasing the question, taking the question from being compound and re-elocute. There's so many ways you can slow it down. There's arguments that when you slow down the question and answer, that's putting a different form of exclamation. That is putting a different form of attention on whatever the concept you're discussing. So it can be of your advantage to create a struggle on the stand with your witness, highlighting whatever that evidentiary moment you're trying to highlight is with that witness. Because remember, some of these witnesses are on the stand for a long time.
Yeah.
I won't be surprised if Proctor is on the stand for 4, 6, 8 hours.
Whole day. Yep, the whole day.
Like I can think of a half day of questions kind of off the top of my head that I'd like to ask him. So
no, it's absolutely it's actually a textbook being written for this and showing other defense attorneys how to handle some of these cases. If you're just joining us now at the 31-minute mark, we have defense attorney Joshua Schiffer joining us and his cat Justice.
she's
in there too.
You, man. She's normally pretty chill. She's all up on me right now. I'm telling you.
So we have 180 people watching. I just want to thank everybody for showing up. And please remember to like and subscribe. And also, for any of the high maintenance ladies that are in the room, you're welcome too. I had to get that one in.
Was that not a moment where you're like, oh, bro, come on, man. You cannot be doing your dude, that you're paid. Yeah. You pay for that one afterwards. But that
Tristan slept in the living room last night.
But that's the joy of the live testimony, and it's the serendipity of it. It's really where the beauty of good trial lawyering comes out, because you can only plan so much. And Sarge, you know how it is. The best plan, it hits the floor as soon as bullets start flying. You can have all kinds of plans.
Yep.
Then you're there. You can only put so much in practice, in motion, before showing up that day. And like the blob comment from yesterday,
yep. We're going to get into that.
Hearing about that. That's going to become a big issue that hopefully the lawyers are going to be paying attention to. Because the lawyers, after this whole day in court, they're going back and reading a lot of this media, trying to figure out, what the game plan is, assessing and analyzing all the different perspectives, because all social media is, it's a potential generic juror. And while it's not going, what you see on social media is not going to control what happens for your case. It's like when you're coaching an NFL game or an NBA game and you're making adjustments in your strategy. If you see something getting highlighted, you can then respond back in court. And we'll see. Certainly there's high stakes, high end lawyering going on in this case.
Yep. So since you brought up the quote unquote blob, so that's Julie Nagel. She's on the stand. She's Brian, and she is hanging out at the house. She's inside the house. She calls her brother Ryan to come pick her up, and then turns him down. Right?
Who is apparently like a taxi driver as well as a plow driver. These people drive each other around in the middle of the night like nobody's business. It's wild.
Yeah. Listen. If my sister called me up and said, "Listen, I need to come pick you up," I'll come pick you up. But if I come in the snow, you're getting in that car one way or another. I'm not leaving after all that.
Yeah, there's literally a blizzard happening. And hold on. I haven't seen anybody who wasn't having some cocktails at some point during this night.
Yeah.
And again, that reflects on this jury pool, which we know virtually nothing about. I have people down here talking to me about all these bar scenes, and oh my God, these people say, "But that's regular." There are people that go to bars and drink and hang out every single day. So you've got to remember that there are jurors that are going to find a lot of this behavior either shocking or completely generic and acceptable. And you never know which juror you're going to get.
Right. So let's talk about this. So Julie has said that she sees this blob. Now, it kind of contradicts, or not kind of, it contradicts what her brother says. All right, her brother is basically, she's saying that she sees it from the window, and when she comes out to the car, she doesn't make any mention of it. The truck, I think it was a Ford F-150 specifically.
Yeah.
He's in the Ford 150 with two other people, and he says not only when he sees the SUV in front of them, he even gives a description of a blonde and a 10 and 2, right? Everybody, of course, everyone's driving appropriately. Everyone's drunk, but they're all
of course.
driving appropriately.
Yes, I checked all my signals and mirrors and did a tire pressure check before turning.
Roll down the window and put your arm out and make sure that nobody's coming.
Yeah. It really, and so now we get into how juries work in contradictions. Is this a legitimate major issue that a juror can attach to and say, hold on, it's impossible for these two things to exist at the same time? Or is this something that we as outside viewers have attached to because we're so involved and we're making a big deal about it? We don't know what the jury's really going to do with something like that, even though it does seem incredulous to us that a 6'2", 200-something pound guy, how do you miss that? I don't know how you miss it. I can talk a lot about the science of your eye when your optic nerve receives images that derivate from what you were expecting. There's a psychological reaction to it. So your eye is actually drawn towards things that are different. That's part of self-defense. It's because your eye should dart towards the tiger before it's supposed to eat you. So you should see something as different as a big disheveled blob in the snow where that shouldn't be. Anybody that spends a bunch of time in New England knows what it's like being out there in the dark and the snow. It's gorgeous, but it also highlights things like big dark blobs in the snow.
Yeah. And it was actually even an attempt, I think, to further dehumanize this guy, right? So John O'Keefe, I mean, this victim, they don't even mention his name. They, refer to him as a blob, and they refer to him. It's craziness, actually. In this whole.
It's weird that because you're 100% right. You've done case. The state needs to be on message with that language selection.
Right. And call it out every time and say that blob was John O'Keefe, right? Put a name on him. But Lolly seems to be sleeping at the wheel here. And I don't understand. Like every time they say that is, it should be objected. He has a name. The victim has a name.
Now, what's your opinion? And I kind of would love to hear other people about the idea that this is a case within a bigger case. And there is this long-standing idea that this investigation ended up being wrapped into a larger generalized corruption investigation into quote-unquote law enforcement. Now, anybody that works in white collar and public integrity can tell you every jurisdiction of every major city has an FBI agency, an FBI office that's always investigating local corruption. It's just a fact of the matter. So the fact that an investigation exists and that there have been complaints, that doesn't move my needle at all. But what do you think about the idea that somehow this case is the evidence in some overarching federal investigation, or is that just people blowing smoke?
Well, I've been on the record early saying that this is not a conspiracy. This is incompetence, right? So we started off, they started off with Karen Read was framed, and then the defense has gone off and proven how ineffective and incompetent the police were. So to me, that I thought there was a contradictory statement in regards to the cover-up. And I said, the state police involved, the local police involved, the district attorneys involved, the state crime lab involved, to get all these people. And I used, actually, I think it was on Court TV, and I said I live by the Ben Franklin quote, 3 people can keep a secret as long as 2 of them are dead. And you're dealing with a situation where, are there cracks in the armor now appearing certain aspects? Yeah, but they're still not proving to me conspiracy. And then people say, well, all you need is 2 people for conspiracy. Listen, I know the pro Karen Read camp, I understand this, but they're making the same mistake as the anti Karen Read crowd, where you are picking and choosing the evidence that you like to prove your theory. And we have told detectives not to do this forever, and that we're seeing it on both sides. I understand that it's all about theater and entertainment right now. Unfortunately, you're dealing with people's lives as entertainment. But when you're having a situation where, people are just, oh, well, what about this? Or what about that? Listen, if I kill somebody in my house, I'm not dumping them on my front lawn. I'm sorry.
It's the baby with the bathwater issue with this picking and choosing of facts. And you're totally dead on that the stands, the Karen Read stands, They just, it's just too much. They lose credibility when they keep following some of the logic that they're relying on. You've got to understand that no trial is perfect. No investigation is perfect. They can be much better than what we're seeing here. But any expectations of perfection in criminal prosecution and defense, and you're going to be sadly disappointed. And guess what? Juries convict on imperfect evidence all the time, and
Yep.
juries disbelieve wild allegations all the time. It's super hard to understand how a jury received the arguments that they're presenting. I know everybody's making a big deal about how the defense opening just started with framed. And that is a really effective way to present that. I mean, come on, we're all still talking about it. But reverse roles with that juror. You're sitting there, there's 12 of you, it's this teeny hot courtroom. Well, this thing is jammed. Oh, this must be a pretty big deal. Yeah, I think this is a big deal. This isn't like any other case. Hold on. What's this guy screaming at me about being framed? That may have landed really poorly. It may have landed really strongly. But it's about how the state is slowly building that case. And remember, the state still has a lot of emotional baggage to deliver to this jury. They've yet to really, in my opinion, present John O'Keefe, the person, in a way that humanizes him as much as I'd like to see. I'd really also like to see a lot more slow down discussion, and hopefully this is going to happen better with Proctor, about the mechanics and the disproving some of the theories, while also admitting the state doesn't need a perfect case. And we're going to hopefully see the state emphasize that beyond a reasonable doubt doesn't mean there's no possible way it happened.
Right. And it's not over yet either. The state still has an opportunity. But I think there's going to be basically the defense going forward. Like, so Julie Nagle is going to be on the stand again today to finish up. So, and correct me if I'm wrong, because you're the defense attorney. They need to impeach her testimony because you got contradictory thing about when they see this SUV, her and then Katie McLaughlin. I mean, and that's the other thing that they need to impeach. So let's talk about Julie Nagle. So put your defense attorney hat on for me for a second. You, knowing what we know from yesterday about the vehicle and her brother seeing it one time, she's seeing it another time, how would you go into this questioning today, or what would you like to see? Let's put it that way, so I'm putting you on the
well, it's about, do you want to highlight or hammer? We all picked up on the inconsistencies, and clearly in court, everybody's ears kind of poke up, and we're talking about this teeny tiny courtroom. What people really don't understand, this is the size of a dorm room, basically. They're jammed in there, all up on top of each other. That, the impeachment, well, so let's talk about impeachment as well. Prior inconsistent statements or inconsistent statements among testifying witnesses are forms of impeachment, and it's basically calling into question the truthfulness, veracity, or reliability of some specific statement. And you're doing that by illustrating something contradictory to it. And here we've got testimony about what observations were. You've got some very specific times involved, and it's the contradiction between two individual witnesses who are primary sources of what was happening live on the ground. It's important for us because if you're the state, you're trying to establish a clear, concise, easy to follow timeline of what happened during that night that fits your theory of the case, which is that Karen Reed ran over and killed Officer O'Keefe at this time, The defense doesn't have a burden of proof. Remember that. They haven't claimed an affirmative defense. They have put forward this framing defense allegation, but they also still get to rely on all the other defenses that are out there, even when they're not being explicit. And one of those generalized defenses is that the state can't keep their story straight. One of those generalized defenses is You can't be certain of what happened because even the state's own witnesses aren't certain of what happened. How can you reach beyond a reasonable doubt when you just heard the state's own witnesses can't tell you exactly what happened? And you're giving the jury, as a defense attorney, the hook to hang their hat, because jurors have that fear of wrongful conviction, wrongful acquittal. If you're trying to get them to acquit, you've got to give them a reason that they're comfortable going to sleep at night, not having proved the burden of beyond a reasonable doubt. And listen, the reason I just couldn't convict him is, man, the state was telling two different stories. And when the state's best witnesses came up, the state's best witnesses couldn't even keep it straight. Now, some jurors, that's going to be the absolute safe zone, and you are hopefully will have identified those jurors. You will hopefully have targeted that argument to those jurors specifically, even though you're casting a wide net to the entire jury with inconsistent statements. At the same time, there's a bunch of dangers when you're impeaching people, because you can be a real jerk about it. And the worst thing you want to do as a defense attorney is get up there and hurt your client in an effort to show that this state's witness isn't telling the truth, changed their story, isn't reliable, is a liar, whatever. I don't know how you feel, but I don't like it when people just walk up to me and call me a liar. You have to, when you're a trial lawyer cross-examining someone, you have to get the jury's permission to call someone a liar. And you're going to do that through a cross-examination. And that's also, this is going with that impeachment, where before you can light into them, you've got to build to it. If you just walk right in, rip the Band-Aid off and start screaming at them, everybody's going to run to protect that witness. And you don't want that.
And I think you bring up a good point, because if you remember, they called, it was Yannetti called McLaughlin. He said she perjured herself after the whole day was over. And then yesterday, he didn't say that when he was talking about Julie Nagel's testimony. He refused to say she perjured herself. He just basically said there's inconsistencies in the whole thing. And I think he learned a lesson there, because they might have gotten a reaction from the jury that we can't see, of course. But I think maybe one of his attorneys there said, boy, don't use that word unless we're 100% sure, because that didn't go over well.
And you can feel it, man. You've been in court, man. If you're sitting, especially in one of these tight courtrooms where the emotions are turned up to, one spot below hell, you can feel the air leave the room when someone asks a dumb question or steps out of line, because you've got that telly. It's why the uniqueness of presence is so important, and why I'm so against virtual hearings in day-to-day court work. If there's something to be contested, you've got to be there live, because you can feel, and the jury can feel, when the question lands with a thud, or when the question is being thrown in an aggressive way, when it's being used as a cudgel or a spear. And there's strategy involved with that, because remember, the win for the defense, it may not be the win we're all thinking. If the defense wants to show that she doesn't remember things the same way other people do, that's one concept. If the defense wants to show she has a reason to lie, is lying, and is part of an act of cover, that's a totally different conclusion you want the jury to bring. And you don't need to have her admit to the conclusion. And let's peel back a little bit in cross-examination. And this is something that kind of blows people's mind when I teach it. The answer doesn't matter. When you're cross-examining people, you don't know what their response is going to be. You can have thought about it, gamed it, read their depositions, interviewed them before, but you can never be guaranteed what their answer is going to be. So when you are practicing, drafting, and creating your cross-examination, you do it in a way that whatever the answer is doesn't matter. You want the juror to listen to the question or statement coming from your mouth. And then whatever the person says, it can fall off into the water. Because
like Tristan.
cross-examination is your opportunity as an advocate to basically testify. You know how people hear the objection, that's a narrative, that's not a question. or that calls for a question. They're trying to prevent the lawyer from testifying and pretending the testimony is a question to the witness. An effective cross-examination is storytelling. And to tell that story effectively, it can't really matter what the response from the person is. You'll
I'm
see
sorry.
lawyers literally just walk right over the responses.
And I forgot her name. The female lawyer got really frustrated with Tristan. I mean, oh my God, that guy doesn't know anything, and it's just.
Well, and so let me ask you: you've worked with humans for a long. What's your takeaway? Say that guy's not talking about a murder. Say that guy's talking about a car wreck.
Yeah.
What do you think about that guy?
He's well, he's definitely not paying attention. He might not be that intelligent. I mean, these are the kind of things that you would come to think about, and it's important too. You know, and I fault, this is what falls on Trooper Proctor, where this case, the investigation took so long to start. People's memories fade. I mean, sometimes you're dealing with a day. We're talking about over a year in most cases, and sometimes within a few weeks of trial, almost right until the arrest.
An indefensible gap in time is.
Yeah, so you can't really blame this guy for not remembering certain things, specifically time, because, and I said this yesterday, you don't. When you're during your normal course of activity, you don't realize that maybe 6 months from now you're going to be in a homicide investigation. So let me make sure when I pick up my sister, I know what time it was.
And then when you see that in action with a good defense attorney, with good cross and direct, you can do a lot with that. That witness is now malleable in your hand, because if you want to show them as being uninvolved and dumb, that's something you can do. If you just want to be gentle with them and show that you feel bad that they had to be involved with this and they just don't remember, that's another ethic that you can go for in the manner that you cross-examine. And that's really why people always say you win criminal trials in cross-examination. There is, every stage of trial is important. There is no more important part than cross-examination, because it's really the only time that your client's going to get to testify. In most criminal cases, the accused doesn't get to testify. So cross-examining the witnesses in the investigation, that's your client's best eyes and ears. And it's the eyes and ears that jurors are going to listen to, because they're ostensibly not self-serving statements offered to prevent someone getting convicted. No, these are law enforcement. These are witnesses. And there's value to rely on some of their statements as being really good, but while at the same time highlighting problems with their memory, highlighting that they corroborate the failures of other witnesses. One of my critiques of the defense is that in all of these cross-examinations, we haven't seen these lay witnesses testify, or sorry, we haven't seen these lay witnesses comment much on the police investigation that they witnessed in terms of effectiveness or what their experience was, which is odd considering how exposed to law enforcement everybody in this universe is. I'd like to see a lot more testimony about how, man, these are first responder families. If you know them, you know them.
Right. Yeah, no, exactly. And this is where the second impeachment, I think, has to come in with Katie McLaughlin. She's the firefighter that allegedly hears Karen Reed say, I hit him, right? So the defense needs to, get her testimony out. And that's why I think we saw that line of questioning with Caitlin Albert about how friendly they are, right? So we're redefining the definition of friends and acquaintances.
Well, and look at what that's done in front of the jury. It took an issue that no one thought, hey, are we going to spend a bunch of time arguing over whether these two women were friends or not? No one really was worried about that going in until the prosecution and their witness preparation basically created an issue for the defense to exploit. And by pushing back against the bias, I would have managed the witnesses differently if I'd been the state, because in my opinion, the testimonies made it seem like the women are trying to hold each other apart and have some distance, when plainly that's not reality. I believe juries are much more forgiving of admissions of basic minor issues, errors that aren't going to be persuasive or substantive or move the needle, such as the fact that all these people all went to the same high school and have known each other. Why? Because it's small town South Boston. Man, all these people know each other. All these people's parents know each other.
They're all related.
Yeah, this isn't Brooklyn. This isn't L.A. This isn't Chicago. No, this is a high school. What? Everybody knew each other. Of course, they're all at the same house parties. Now, did those questions get answered with a giant thud? Yeah, because we all know you know each other. And don't lie about that. That's a dumb lie. And that evasiveness, when a defense gets the opportunity to show multiple state witnesses, all with a same or similar evasive demeanor, that's a big problem for the state. Juries need to have confidence in state witnesses because of that fear of wrongful conviction, wrongful acquittal. Because when a jury signs their name to the verdict, they need to be able to say, yep, it's proven beyond a reasonable doubt, and I can sleep at night.
How do you think the jurors are taking that Caitlin Albert testimony about, right, basically we're not really friends, and then all these photos are showing up, and then having this thing of the firefighter saying I hit him, I hit him? Do you think that was enough to impeach her testimony in that kind of respect?
So one of the exercises that we do when I trained for a long time, I was a member, staff member of this thing called the Trial Lawyers College, training lawyers in some trial techniques. And one of the tools we use is role reversals with prospective jurors. And you create in your mind a character. And it's a fun exercise because you need to create your juror since you know your community. And we would then ask, when we're working on these cases in group form, we would ask 4, 5, 6, 8 participants, all right, pick your jurors and reverse roles and become your juror. And when you do this exercise time and time again and think about character development, you crystallize in your head exactly how different perspectives work. And me viewing the exact same situation from the eyes of my mom, who just turned 80, versus my opposing counsel in a case who is a mid-30s insurance defense guy. And then I've got another juror that is my daughter's old preschool teacher. And then I've got another juror, which is one of my old high school teachers. And they all have these different perspectives. Yep. So when you look at a specific fact, you've got to understand how that fact landed with the different perspectives and how those perspectives work. That's going to determine the stimulus coming back. So there's really a lot of different interpretations that come out of that testimony. I know some jurors would be completely pissed off and hate her. I know some jurors that would go, who gives a shit?
Right. But that's all you need for a hung jury, right? So that's the defense's plan, right? I mean, at the very least, I mean, this is headed that way.
You can get a game. I'm not trying to get 12 people to sing Kumbaya. I'm trying to get 12 people to disagree.
Yeah.
So when I'm appealing to a jury in a criminal case as a defense attorney, I'm trying to identify, cleave out 2, 3, 4, 5 people. If I see someone's stimulus pop up, if their eyes and ears light on fire when I start doing something aggressive, aggressively cross-examining and impeaching someone, my assistant or someone at my table is hopefully going to go, oh, dude, when you were lighting up, that juror totally was engaged and turned on. Man, if that's what that juror responds to, let's give that juror more of what they like. Whereas if you see the shaking head, sourpuss face, I didn't
cringe.
like that. Man, that can be really good.
Yep. Oh, we lost Josh there. I wonder if Kitty Justice took out his his camera. So, Cake Spoon, thank you very much for your sticker. Nagels Road Bagels. Yeah, I hope Josh is able to come back into the room, because that was I didn't want to ask him another question before we wrap this up in regards to Proctor, if he has a chance to ask Proctor. Yeah, Forensic Fuhrer, Kitty has signed off. Kitty's like, all right, enough. I had enough. Pet me. So it's pretty interesting. So As we're waiting to see if Josh can come back on, let me look at my phone to make sure he's not trying to send me a text message. Yeah, so that was actually an interesting sign off, right? So we'll see what happens. I know coming up today, we got the Defense Diaries and the Shaming of Jay. They have a show going on right now. Here he is. Very good. Hang on.
I don't know. We had a power blink go through right at 9 o'clock, so the aliens may be coming.
I think Justice finally said, "All right, I had enough. Pet me, Daddy." Right? So this kind of thing.
Hey, sorry, we need to do this conversation again because I could talk a lot more, and I like talking with you because
I would love to have you back on, and I like to do the. I'd like to have maybe a day before Proctor goes on, if you're available.
Oh, man.
We could talk about that,
and we could get a couple other friends together because this Karen Reed case, I love it and I hate it because it's everything that's good about true crime, but it's also exposing the seamy kind of awfulness. Because really, there's some awful that's going on this. Is our system getting manipulated in good ways or bad ways? Yep. And I worry about that. But thanks so much for giving me the opportunity to come in and talk to you, Sarge.
Thanks a lot, Josh, for coming on in there. Listen, we'll do this again soon, especially with before Proctor. I think that'd be great.
Dude,
you hang out 1 second, Josh. We're gonna end this. Everybody, you guys have a great day, and we'll see you on Friday for roll call, 8 a.m. Talk to you soon, guys. Bye now.